introduction, and thank you for coming today. I'm afraid my English ability, but I try to do my best today. And first, let me introduce myself. My name is Uenishi Takahiro, and Jewish doctor student of Chuo Law School. I have stayed in Hong Kong for about 3 weeks, and the first week I took some class with Korean students at Hong Kong U. After that, I worked at Hague Conference Asia Pacific Regional Office as Marshal. My boss is Mr. Reyes, and I translate English principal to Japanese here. I need to prepare the bar exam in Japan coming on May 2017, but I choose to spend this winter in Hong Kong, and I got precious experience here. Today, I will talk about management buyout, MBO, which I am interested in. I will explain how court should assess the reasonable price in MBO. I talk about how the court should take the way to assess a reasonable price in management buyout. First of all, I'll show you today's outline. First, I will shortly talk about MBO. What is MBO? What is the purpose of MBO? We often hear the word MBO recently in Japan, and we often hear. Second, I will show you the important issue of MBO. The issue is how should judge assess the reasonable share price. In MBO, there are conflicts of interest between people who buy shares and people who sell shares. In most cases, the former is director and the latter are minority of shareholders. That is why this issue is very important in order to balance the interest of both sides. Concerning this issue, I'd like to introduce Japanese MBO case. And finally, let me introduce Companies Act amendment in Japan in 2015 and some its program. This is today's outline. And first, let me talk about what is MBO. In MBO, all of or some of directors of the company buy their own company shares by themselves. Their capital is limited, so some fund or bank help them to get capital for buyout in big deal MBO case. And what is the purpose of MBO? There are a lot of purposes, but I will introduce main 3 purposes. And first purpose is to wide the director's discretion upon their core business by separating the non-core business sector from the core business. Okay. Second is to resolve the problem of succession. And third is reduce cost, which is burden when the company is listed. Nowadays in Japan, the number of MBO is increasing, and the number of MBO by listed company are getting bigger and bigger. What is the merit of MBO? Most important merit of MBO comes from the fact that the directors could be the largest shareholder of the company. And if so, the directors will set wider perspective and goals about business, and as they are highly related to the profit of the company than before. So their priority of doing the business will be more focused on market profit, not short-term achievement during their terms. And what is the merit of MBO? If the listed company changed to unlisted company, they can't get the benefit which they could get before becoming unlisted company. This includes the benefit from unspecific number of shareholders in market, and the benefit which the companies can get because they were listed company. And then they care the influence of fund or bank because they lend money from bank or fund, so they have to refund money to them. It will have a great influence to directors' decision. Next, how to do MBO in Japan. When we do MBO, we need 2 steps. And there are 3 main ways to do MBO cash out. Today, I will pay attention to the one way to buy shares subject to class-wide call. Now, I'll show you Japanese basic way to do MBO. First step, directors buy their own company shares and become the majority. And they get the right of management. And then they change articles of incorporation and decide to change common shares to shares subject to class-wide call. Okay. After that, they acquire all shares subject to class-wide call and give shareholders common share. But these new common shares are odd lot. Therefore, minority of shareholders have to sell their shares and squeeze out. This is a way to do MBO in Japan. And in Japan, Article 172 reads, the shareholders may file a petition for the court to determine the price of the shares subject to class-wide call for the acquisition by the stock company. What is the issue of here? As I have already mentioned, the director is buyer of own company's share, and they can decide how much to buy shares by themselves. Do you think these directors want to buy their shares cheaper than usual? That is to say, they have conflict of interest. And on the other hand, minority of shareholders have to sell the shares at a lower price. In addition, minority of shares face the asymmetry of information. So they need to be guaranteed the opportunity to judge appropriately without to be given the appropriate share price. How much is reasonable acquisition price? How should the judge assess the reasonable price? From now, let me introduce the Japanese case. It named Lex Holdings case. Before we analyze the case, I introduce you about Lex Holdings. They were originally property management company. In 1997, they opened Japanese barbecue restaurant which named Gyukaku. It became famous in Japan and some other countries, including Hong Kong. There are about 10 branches in Hong Kong. For example, Causeway Bay and Tsim Sha Tsui and so on. Yeah. They declare that they changed from listed company to unlisted company because they need business reconstruction. They faced increased competition in the food service industry and slackness from rapid growth. When they declared to do MBO, they had many businesses, for example, convenience store or supermarket and so on. Therefore, they need reconstruction to do slim down. The director was supported by investment fund and found the company as tender offer. They carried out TOB, takeover bid, and got about 90 shares of all. This was the first step, and the director was next that they changed their articles of incorporation and got the other shares, other less shares. On 17 February 2006, the Lex Holdings announced that their business forecast will be better. However, their share price tend to be going down. Then their share price hold down suddenly because they announced extraordinary loss and downward revision of business forecast. And on 10 November 2006, they announced that they bought shares at 230,000 yen. How did they decided that price? And the plaintiff argued that the share price is rather lower than essential price. After that, on 9 May 2007, the Lex Holdings was delisted, and they did MBO for enhance their autonomy, but actually they ended up being the subsidiary of other food company only after 6 years. I will especially introduce about High Court decision today. According to Article 172, shareholders may file a petition for the court to determine the price of the shares subject to class-wide call for the acquisition by the stock company. The intent of the article is the protection of minority shareholder. The article allowed these shareholders to appeal an acceptable ruling. Therefore, the court shall decide the reasonable price of the shares subject to class-wide call for the acquisition which based on fair price of share acquisition date. In general, shareholders can decide it by themselves when to sell or how long would they possess the shares. They figure out objective value of their shares. Today we call this objective price. And they also have expectation that they may get more value when their possessed share price increase. This expectation should be protected by law, and today we call this expectation premium. Okay. The High Court decided that it is reasonable to consider this objective price and premium in order to decide its reasonable acquisition share price. There are no criterion for deciding the share price, so the court has to decide the price by their reasonable discretion. And let me talk about objective price. In this case, the High Court mentioned 3 ways to decide its objective price. One is the way to depend on market price, and the other is a way to depend on their asset in book value, and the other is the way to depend on the average of similar companies' share price. The court mentioned that the way to depend on their asset should not be considered because the value of company is based on their earning power, not their asset. And the way to depend on the average similar company share price is not the way to depend on the average of similar company share price is not reasonable because we can't make sure which company are similar to that company. How about depending on market price? Generally speaking, not only speculative speculative stock transaction, but also asset component and financial affairs earning capacity and accomplishment affect the market price. Therefore, the High Court decided that the objective price should be based on market price. We have to make an analysis each three terms. Next, I talk to you about a term. That means one term is after the announcement of TOB, and second term is between the media release and the announcement of TOB, and the third term is before the media release. First, I will talk about first term. After they declare the TOB, the market share price were affected by that announcement. Therefore, this share price should not be considered for decided the objective price. Next, I talk about second term. That is between the media release and the announcement of TOB. What are the issues of the media release? The main issue is the suspicion. They declare downward revision of account settlement intentionality in order to fall down market price. However, in this case, they couldn't make last decision by themselves because their director got their capital from investment fund. So the court mentioned that they didn't announce that intentionally. How is the actual share price in market after the media release? After the media release, the share price in market fall sharply from 304,000 to 144,000 in just 50 days to be half. And however, the share price restored to 219,000 because of speculative dealing. Therefore, the court mentioned the price of this term didn't reflect company value appropriately. However, the court also mentioned like this: the court have to decide the company's objective price, reflecting the company's value appropriately, and they have to exclude the influence of unusual circumstance. How did the court exclude the influence? The court have to exclude the influence as much as possible by focusing on average. Actually, market share price don't always reflect the company's price appropriately, and the market share price must be affected by speculative dealing or any others. So it's really hard to figure out the real objective price from market price. However, to consider the average will decrease the influence when the court decided the appropriate acquisition price than decrease the influence than before. Now let me talk about third term. This is before the media release. Should the court consider the average market price before the media release? Considering the market price fall down sharply after the media release, it is not reasonable to decide the objective price by average near the TOB. It must be more reasonable to decide it by average before the media release. What term should the average be based on? the court decided that it was reasonable to consider 6 months market share average before TOB. It means that it includes second term and about 100 days of first term before the media release. There are some reasons for this. First reason, other companies which did MBO around the same time, considering 3 or 6 months average of market share price. And second, according to the guidance ruling by Japanese Security Dealers Association, acquisition price shall be more than multiplying the average market share price for appropriate term by 0.9. Third, they were influenced by unusual circumstance. For example, the share price fall down sharply after the media release. Considering these reasons, the court should consider not short term, but long term in order to exclude unusual circumstance. Therefore, the court decided to consider 6 months market share average before TOB in order to decide the objective price. Next, I talk about premium. As I mentioned, premium means the expectation for possibility to increase shares. How much the premium is? How should the court decide the premium? This is so difficult question. And the court mentioned that there are two kinds of values. One is the value which shareholders would get after MBO. And another is the value which shareholders could get if MBO would not be done. The latter is in principle distributed to shareholders. And on the other hand, regarding the former, you should distribute to directors and shareholders as you consider the risk and effort that the director take by carrying out the business plan with the risk of its uncertainty to realize. The court mentioned that it is difficult to decide premium without stock price calculation evaluation report. Therefore, the court has to decide the premium in their discretion. In Japanese TOB case, the average of premium between 2000 and 2005 was about 12% of market share price when they did TOB. When the buying price is lower than market price, it often means negotiation transaction. And therefore, if the court exclude this case, the average of premium was 27%. In this MBO, in this case, the directors explained that the premium is 14 of a month's share price average before TOB, but they didn't affirm concrete reason and didn't exhibit business plan or stock price calculation evaluation report. So considering these circumstances, the court argued that the premium shall be 20% of objective price. This is the court decision. From now, I will explain my analysis of this case. And first point is, from what perspective should the court decide it? That means the court should decide it from substance or procedural perspective. in substance, the code considers mainly whether the price is substantial or not. For example, the result or the substance of TOB. And in procedure, the code considers if it is transparency or if it is equity. For example, the process to decide MBO, information disclosure system, the existence of independent organization, and so on. Of course, the code should consider both of them. But in this case, the code didn't mention what process or system the company should have. And the code should have paid more attention to the procedure at that time. And second point is the way to decide the premium. In this case, the code decided the premium by considering the average of other TOB case. However, why could the code say that it is reasonable? I think that objective price should be based on market price average because market price reflects the company's value. The premium is not. Premium is different from each company, and therefore the code should have decided the premium by considering each company's situation or purpose of MBO. It is really difficult for the code to decide the premium. However, I think the decision of the code will be better when they decided focusing on substance and procedure and make decision by themselves. What is example of premium? Premium is, for example, to reduce the cost of consulting or listing and profit creation by directors' effort. But these premium don't always exist. We can sometimes find the case which have no premium. For example, when the directors buy shares in order to get benefit from shareholders, the premium does not exist. It is because they can get the benefit just by buying shares in cheap. These cases exist, so the code should not decide the premium by considering average. Finally, I'd like to talk a little about amendment of Companies Act in Japan. Especially, I talk about the amendment of the way to cash out. According to the new Article 179, shareholders who have more than 9/10 of the board of all shareholders of the stock companies may demand all shareholders of such stock companies to sell all of the shares of company. Due to this amendment, shareholders who have more than 9/10 can demand to sell all of the shares without meeting shareholders. Therefore, the protection for minority shareholders gets weaker than before. Instead, I think that focusing on reasonable acquisition price become more important. In this process, the minority lost one protection during procedure. Otherwise, straining the substantive protection is needed. The court should decide it reasonable and appropriate acquisition price in order to protect minority shareholders. Thank you for listening. And thank you, Mr. Reyes, for giving me this chance. And Special thanks to Mr. Kawashima. He helped me to translate English. And thank you for all. And if you have any question, please ask me slowly and easy English, please. Thank you for all. Thank you very much.
Would anyone like to ask questions?
Yes.